Welcome everyone, and thanks for showing up on such a lovely afternoon, spring in Cambridge almost, right? So this is one of the simple events, although in a way it's probably more competition than information or intellectual property law we're going to be hearing about today. I'm very happy to have here to present to you Rupprecht Podszun, a former colleague of mine. We worked together at the Max Planck Institute for a couple of years. He, in fact, did manage to write one of these habilitations, these big theses, the second sort of thesis you have to do in Germany in order to become a professor. I never managed that. I instead just came here. Well, in any case, sorry?
That's a good decision.
Probably, yeah. It spared me 600 pages or so, which you strategically have to write on something you're never going to be concerned about later on, probably at least. Anyway, so, but Rupprecht is also a person who has done lots on intellectual property. I believe he was teaching IP stuff quite a bit in Bayreuth for 2 or 3 years. He's now got a new chair in Düsseldorf, which is a university which is sort of where the proximity to a court in Düsseldorf, which addresses a lot of competition law cases, is quite an important matter. Why they've set up a chair, and Rupprecht got that chair now on competition law matters, which really sort of are the ones which are interesting for practitioners and are interesting for competition law practice. So I'll leave it to Rupprecht to talk about the topic in more detail, and we'll have about, I think, 40-45 minutes to hear from Rupprecht, and then questions and answers, and afterwards a little bit of drinks. So thanks for coming, Rupprecht.
Thank you. Thanks, Henning. I thought you had just brought out a book on international IP law or something, which is probably much more valuable than any German habilitation, but the readers may judge. Thank you for the invitation. I'm very happy to be here. It's really a great pleasure to be at Cambridge. And today I'm going to sort of mix 3 topics that are of interest to me, which may be a bit ambitious, but otherwise I thought I'm in Cambridge, so it should be ambitious for the audience. It's patent law on the one hand, competition law on the other hand, and some bits of legal theory on the third hand. So you may sort of see what this is about when I get into the topic. The topic is contextualizing the IP and competition law clash, an evolutionary approach to the Huawei judgment of the Court of Justice of the European Union that you may have heard about. It's already from 2015, but still sort of interest, or I think it should be of interest. This is what it is all about. This is the patent in a patent case that was actually dealt with by the Düsseldorf court, the court of first instance. Düsseldorf is very famous not just for its competition jurisdiction, but also for its patent law jurisdiction. And this patent, as you will probably easily have discerned from the drawing, is on method and apparatus of establishing a synchronization signal for a communication system. So you've got the transmitter on the left-hand side and the receiver on the other-hand side, and you need this obviously for telecommunications. So it's a patent that deals with the LTE standard, actually, the LTE standard that you may know from your mobile phones. And the proprietor of this patent is Huawei, a Chinese company, that came up with this patent that is essential for the LTE standard that you may use if you want to get mobile phones connecting to one another, or connecting, in this case, to a base station. You probably all know what standard essential patents are. Just so very quickly, a standard essential patent is a patent that you need to use if you want to use a certain industry standard. So once you decide in favor of building products or anything with an LTE standard connection, you need this patent, or put differently, you infringe this patent if you work with the standard and haven't obtained a license before. In telecommunications, we have a standard-setting organization, ETSI, the European Telecommunications Standardization Institute, where you usually, as a proprietor or an inventor of such a patent, go to and declare the patent as a standard patent, as a standard essential patent for that standard. So ETSI registers your patent and says, yeah, this patent is essential for the standard. Etsy doesn't check whether that is really the case. It doesn't even check whether the patent is valid or anything. It just sort of notifies that, registers that, so that when Huawei went to Etsy in 2009 and declared this patent is essential for LTE standard, it meant that this was a standard essential patent. You may wonder how that comes about. There is a deal behind that, and the deal behind that is that once you register your patent with these people, you are obliged to grant a friend license to everyone that asks for this. Friend license means a license on terms that are fair, reasonable, and non-discriminatory, whatever that is exactly. So Huawei decided to do this deal. They registered the patent with Etsy, and the patent was thus declared an SEP, and this meant for Huawei that they have to license this patent to basically everyone that asks for it according to friend terms. Now, it happened what has to happen. Huawei found out that ZTE, another Chinese company, so it's a battle of two Chinese companies in a German court that we see here. Huawei found out that ZTE used this patent, so worked with the LTE standard, and they negotiated with ZTE over a license. Huawei wanted considerable royalties for the use of this patent. ZTE said, no, let's cross-license my patents with your patents so that we get a deal there. And they offered actually a royalty of 50 euros, which for patent lawyers is a relatively low sum, as you may imagine. So they negotiated for a while. The negotiations failed. The day after the negotiations with ZTE failed, what did Huawei do? They went to the Düsseldorf court and filed for an infringement action. That is to say, they wanted an injunction, they wanted damages, they wanted rendered the accounts, and they wanted to recall all the products that ZTE was marketing with the use of LTE standard. The Düsseldorf court decided in 2013 to refer the question to the Court of Justice of the European Union. Why was that? Because ZTE said, if you file an injunction against me for infringing your patent, this means you violate competition law rules. Because under competition law rules, you're not allowed to abuse your dominant position. You, as an SEP holder, are dominant on the market for licensing this patent. And if you file this injunction against me, if it's a patent, if it's a standard essential patent, although I'm willing to negotiate with you and have shown that I was willing, and we just weren't reaching an end in that, it means you violate European competition law rules. And the Düsseldorf court wanted to know in more detail from the Court of Justice of the European Union whether this is really the case. So do we have a violation of EU competition law rules here? Is that abusive? This is essentially the question that the Düsseldorf court put forward. Does the proprietor of an SEP violate Article 102 of the Treaty on the Functioning of the European Union if it brings an action for an injunction against the patent infringer, even though the infringer has declared that it is willing to negotiate? Actually, the question was far longer than this, but I try to reduce it to the minimum here. What we see here, actually, and this is what I'm talking about today, is the clash of patent law on the one hand and competition law on the other hand. So we have a right by an IP right holder, the right to exclusively use the patent and to exclude others from using it, infringers basically. And on the other hand, we now have a competition law defense against that under Article 102 TFEU, or that is claimed at least, saying you violate European competition law rules if you file for such an action. And this action, as IP lawyers would instantly agree, is actually the pure exercise of my core IP right, namely excluding others from using it. So we have a clash of IP and competition law here. Just sort of as a reminder, Article 102 TFEU is the central, or one of the two central norms of competition law under European competition law. It is the simplest and easiest and shortest provision probably you could think of. It basically says any abuse of a dominant position is prohibited. Unfortunately, it is so incredibly simple that it is incredibly complex if you try to apply that, because you have to define what is the market that the parties are on, what constitutes a dominant position on that market, and what is, above all, an abuse. So you have three incredibly difficult questions, and this is basically everything that the drafters of the treaty ever gave to us. So you may ask yourself now, is that actually an abuse of a dominant position? In this case, the court said, and the Düsseldorf court held, that an SEP holder is dominant under any circumstances. The Advocate General actually doubted that in his opinion, but the court never sort of said anything on that, and the referring court, the Düsseldorf court, said that is so they had to accept that for the pending case. So we won't go into anything on dominance here. Just sort of for those of you who are not so acquainted with competition, or dominance means you have certain market power, maybe a monopoly. In this situation, you would probably have a monopoly because you're the only one who can license this, who can grant this license. So you have no competitors, you have market power, and you are not allowed under competition law rules, under this rule, to leverage this market power so as to hinder competitors from entering a secondary market. That's the typical situation of Article 102. So you are dominant on one market, and you use the market power you have there to become dominant or to have a great influence on a second market that is the aftermarket to the first one. So, for instance, selling mobile phones or selling base stations for mobile phones. This is basically the question that we have before us, and I'm showing you on this slide now what competition people say on this. This is Joaquin Almunia, who was the Commissioner for Competition in the EU Commission. At the time when the court got this case, and he spoke very clearly on how he sees these cases. I believe that injunctions should not be available when there is a willing licensee. Ideally, this principle should be implemented by the standard-setting organizations themselves. So it would be the obligation of ETSI to make sure that there is no injunction filed by Huawei. But since that is not happening, I am willing to provide clarity to the market through competition enforcement. So in 2013, the competition boss in Europe says, I'm going to go against all people who file for infringement actions from patent law if we have a standard essential patent here. You'll see later on how that develops over time. The question that I put forward here is, how does now the judgment in this case shape the debate of IP versus competition law? And I'm going to show this to you in a couple of steps. First of all, I'm going to discuss the case a bit with you, and then I'll blend in some evolutionary legal analysis to reach some conclusions of this case. Just as a reminder, where do IP and competition law really interact, or what were the cases? Some of you may have followed that in the past years, that IP and competition law often came to a certain conflict, and that competition people tried to remedy all the problems that IP people built up over the past century or so. And sorry, Lionel, this is just speaking the truth. This is some of the landmark, or maybe the landmark cases that we dealt with under competition law auspices. Pay for delay, judge ruled by the General Court last year in the Lundbeck case. Is it possible that pharmaceutical companies pay for, generics companies for a later for delay in market entry, or is that a violation of competition law? Judgment last year. The refusal to license cases, you may be aware of the Microsoft case that was in 2007 before the General Court, where Microsoft was obliged to give away trade secrets, which is sort of IP-ish, and was sort of forced to open up interface information for other software companies under competition law. Then we have cases on standard setting and now rules on standard setting. So how, if we as an industry meet, how can we set standards so that it is not anti-competitive? An interesting case on that was the EMC case, a case that dealt with the cement industry, so something completely different from other, from the now new technologies, etc. But we have that problem in those industries, of course, as well. Court ruled on that in 2011. We have even cases where it's not so much about the exercise of a patent, but about the getting a patent. The most prominent one is the AstraZeneca case, where AstraZeneca registered a blockbuster medicine, or tried to get some prolonged protection for a blockbuster medicine, and the court and it actually played foul with the patent agencies, and it was held that this was abusive patenting, a problem that should have been remedied probably in patent law, but was remedied actually by the European Commission in the AstraZeneca case. The court decided that case in 2012. Then we've got technology transfer. Whenever you draft a license, so transfer technology to other people, you need to comply with competition law according to the technology transfer block exemption regulation, and a case on patent ambush that was pretty prominent in 2009 when the Commission decided against Rambus. Rambus hadn't disclosed that they actually held a patent during a standardization process and later tried to exploit the others that had to use that standard with their patent, and the Commission saw this as an abuse as well. So just sort of to map where we are mostly here in this field where Microsoft is, where we have the Microsoft case. The overarching feature of the field of IP and the field of competition law, as I would define it, is actually innovation. In competition law, we always claim competition law is about making companies work efficiently and making companies come up with new innovation. In IP law, obviously, it is all about innovation, at least in patent law, so we want to foster innovation. But apart from these sort of very general aims, IP and competition law have very distinct features. IP deals with exclusivity, so it grants you exclusivity, while competition law is all about the opposite, namely market access and non-exclusivity. The legal basis for IP is in the Charter, in the Charter on Fundamental Rights. The Article 17, Para 2, specifically protects intellectual property, while on the competition side, we have a certain provision in the Charter, Article 16, freedom to conduct a business, actually invoked in this case by the Advocate General, not invoked by the court. We base competition law on primary law in the treaty in Article 102 typically. The state intervenes in IP law by conferring rights. In competition law, it restricts rights. We have certain limits to this sort of state intervention. The typical limits of IP rights are the expiry of IP rights, the limitations and exceptions of IP rights. While in competition law, our typical limit is that we always need the market share thresholds or certain market power in most cases, unless it's really collusion or anything. And the economic rationale behind it couldn't be sort of more differing. In IP law, we give an incentive to invest, and this incentive to invest actually is a monopoly rent to the inventor, while in competition law, everything is about cracking monopolies in order to achieve a higher consumer welfare. This is, of course, a very superficial distinction, but I think it represents that pretty well. What is the problem, in fact, that Huawei dealt with? It's this problem here. This is a mapping of patents in mobile phoning. If you can read it, lucky you. Otherwise, I just tell you what you would be able to read if you could. These are names of companies, and whenever you see a company name with a dot, sort of, they hold a patent. And so Nokia or Qualcomm or Samsung, with very, very large red dots, they hold a lot of patents. And all these patents here sort of overlap. So we call this a patent thicket, as you may know. So we have the situation that we have a set of patents that belong to many firms that protect overlapping parts of the technological sphere, of the technological space that we're dealing with. And this is for telecommunications and mobile phoning only, and you can imagine what happens here. Actually, in the court ruling on Huawei, the court found that there are, in the LTE standard, 4,700 standard essential patents. They didn't really disclose where they have that number from, because I read other figures which were around 2,000, but okay, the court dealt with a problem where we have 4,700 patents held by at least 40 companies. So you can imagine, if you want to strike a deal with all of them in order to be on the safe side once you market your product, it can be pretty overburdening your company, essentially, if you need to strike a balance for that. Now, just think of patent trolls in this, right? Companies that do not produce mobile phones and hold a patent. You may remember the BlackBerry incident a couple of years ago. What happens if there's one player who doesn't really play according to the rules, that basically everyone patents everything and cross-licenses everything, because he doesn't have an interest in marketing that? He can basically hold them all he could ask for infringement decisions. So this is the patent thicket. This is essentially the problem that we deal with in this case. And just sort of for the impact of that, Hall, Helmers, and van Gravenitz have produced a study for the UK government on patent thickets in 2016. They are very sort of cautious in their results, but they say our evidence indicates that patent thickets raise entry costs, which leads to less entry into technologies. Imagine you're a new inventor and want to get into LTE standards with 4,700 patents already, right? Carl Shapiro from the US already as early as 2001 saw this problem and said, in short, generalizing this is hard for you again, Lionel, sorry. In short, our patent system, while surely a spur to innovation overall, is in danger of imposing an unnecessary drag on innovation by enabling multiple rights owners to tax new products, processes, and even business methods. So we may have a problem here that is more general, a problem of the patent law system nowadays, at least in some industries. I think it doesn't extend to all industries, but it is certainly true for telecommunications. So this is basically what the court is about, the case is about, and so the question coming up for us is, does competition law provide a shield against patent law enforcement? That is essentially what all this is about, and which then in the end sort of amounts to compulsory licensing, something that patent people, of course, would not sort of favor very, very strongly. This is the reasoning of the court. The court in its decision says, competition law may only intervene in such cases in exceptional circumstances. So usually you're allowed to exercise your right, your IP right, unless there are exceptional circumstances. It cites certain case law for this, Volvo, McGill, IMS Health, and Microsoft. It actually doesn't cite Microsoft, that's why it's string out, but actually should have cited Microsoft, but Microsoft was decided by the court of first instance, as it was then called, so maybe it doesn't really play a role for the court, I don't know. And it distinguished actually the current case from these cases and said all these cases have nothing to do with it. The only thing that we accept is that competition law may only interfere in exceptional circumstances. And then it goes on with the following reasoning. If you give the promise to negotiate a friend license, this means you raise specific legitimate expectations for the infringer, for ZTE in this case. And if you then disagree about the friend royalties, so what is friend, it means that we need to find a fair balance. That is basically the reasoning. I don't know exactly what that has to do with exceptional circumstances or what that sort of doctrinally is. I don't see that. But I have drawn up a model, what the court continues to say, and it was so complicated that I did it in handwriting because my PowerPoint skills are not so... well, the court said, it is abusive if the action interferes with this process, so with this sort of fairness negotiation process. And it then developed sort of a scheme, what it sees as a fair negotiation process. The proprietor, who gave a friend agreement to the SSOs, needs to alert the infringer. The infringer has to show its willingness that it will pay royalties. Then the proprietor has to make a specific offer according to friend criteria, and if the infringer is not happy with that, it has to make a specific counter-offer according to friend. If they don't reach an agreement, they go to a third party that determines the royalties. If the infringer continues to use the patent over this time, it needs to provide security, for instance, a bank guarantee that it can really pay the royalties at a later stage. So this is what the court has in mind, this is how it should all work, and if one of these obligations, as the court puts it, is infringed, the infringer may sort of step forward with a competition law defense and say, you have not alerted me in the right way, so it's abusive if you file action now. Or you haven't made a specific offer now, so it's abusive if you now file an action. Right? While it is not abusive if the infringer has not responded in a willing way and showed that it would sort of negotiate. Yeah. What did competition people make out of that? Just after the judgment, Margrethe Vestager, who succeeded Joaquin Almunia, said, our task in this regard is to find the right balance between the interests of distributors, artists, inventors, and creators, and the interests of consumers. So the approach right after the judgment is distinctly different from, in my view, from what her predecessor said, who said, we're going to make clear that you may not file action. Now, Vestager in 2015 said, oh, we have to balance, right? So she sort of probably accepted in a way that the court takes a sort of negotiating stance here, a balancing approach. Now, I want to quickly go through some basics of evolutionary legal analysis to take a second look on the case. This is just to introduce this sort of theoretical strand to you, just to give you an idea of how I approach this. Don't worry, this will not be a jurisprudence lecture after all. Evolutionary legal theory starts with Heraclitus, who is a Greek philosopher who said, well, you're all able to read that, right? You're Cambridge people. So the English translation would be, everything changes and nothing remains still, right? So everything is constantly in change. And people like me who take an evolutionary approach to the law say, yes, this is true for the law as well. The law also constantly changes. And you will probably all agree, the law constantly changes in the sense of we get new judgments, we get new statutes, we get new sort of ideas, principles, etc. So it's a really trivial commonplace. But on the other hand, at least for statute-driven member states of the EU, I think that it is also pretty radical to think in this way, because our understanding of the law typically is that the law is something static, something with eternal value, something that is right. And if you think of Ronald Dworkin's theory, for instance, of Judge Hercules, who always finds the right solution to a legal problem, probably today, exactly in the same way as 2,000 years ago, you would probably say it's not in constant flux, it's not something that constantly flows, but it is something that is there and it has eternal value forever. So ask yourself, if you're from a statute-driven country, I don't know about common law countries so well, but if you're from a statute-driven country, you would probably very deeply in your heart feel that the law is, and not that the law is something very dynamic, right? I feel that is entrenched in our understanding of the law very often. If you move to a more dynamic picture of the law, my idea of that is that the law is essentially a discovery procedure, as Hayek called competition, a discovery procedure, something that is open with an open result, where we make new innovations, where we find new things every day, basically, as soon as we come to that. And this actually distinguishes my sort of taking of evolutionary theory from others who have an end in mind. There is a school of law, a school of legal thinking that you may know by Judge Podszun and others who think common law, for instance, always develops into an efficient direction. I wouldn't say that. I would say it develops whatever is the outcome, right? So it's not necessarily to an end, but it's much more freely than this. So evolutionary legal theory focuses on this legal change over time, on innovation, if you may so. So our task is basically to see this discovery procedure over time and to identify patterns, how the law develops, because that makes it interesting. And we have a model for this, and now this is the Cambridge turn of this class. I started with the Düsseldorf court, now I come to Cambridge, because we have a model for this, and this model is, of course, the analysis of evolution. Look at this, I even designed that. This was the most daunting task of this whole PowerPoint, to design a Cambridge scarf, right? Okay, Charles Darwin invented the theory of natural selection, so he was sort of the pacemaker of evolutionary thinking, and of course a Cambridge personality. And since you are all studying here, you have all read his book on the origin of species, and you are all aware of how that works. It's a good read, really. I recommend that to you. This is essentially how evolution works in biology. You reproduce. Something is reproduced. There is a variation. These variations grow, and there is overpopulation, so that it comes to competition because there are scarce resources. And not all birds can survive, basically, so that some birds have to be selected over others. Once a certain variation in a bird has been selected, we need to stabilize that. It is stabilized in a certain way in nature because it's selected again and again and again. And then it is adapted, which means that this distinct feature, the variation, is sort of embedded in the genetic material, in the and sort of is the starting material for the next evolutionary process. This is what we call evolution. So evolution is this procedure, basically, just very quickly. And it starts again and again. And I think we can equate that with the law, because the law also is facing new challenges day after day. And I think it works pretty much in the same way. We have another case. This case has differences from other cases before, differences in fact or in law. So if we have certain variations of the law, conflicts start arising or growing, courts discuss this, researchers discuss this, and we need to select something for making the law more stable, to making the system more stable. So an authority decides about this. This selection of a certain variation is confirmed. For instance, since Henning quotes this judgment as essential in his book, so then it's a confirmation. It enters into the textbook. It is new material that the next court that deals with the matter has to take account of. That is what I would call legal evolution, right? A process. So if I take this as legal evolution, I now see it as sort of my job to look, okay, how do things change and what patterns do we have, for instance, for selection? And how can we foster different variations coming up? So we observe this from an empirical viewpoint. We identify patterns for legal innovation, and I try to sort of promote a legal regime that is adaptive to change, that is able that comes up with diversity and ends up in being very much more adaptive than a very static system. But that, of course, is something that you can disagree on because it's just a sort of political question. Darwin gave us some ideas of when evolution works best. And this is just 5 points. So when do we have a lot of variation? When do we have a lot of sort of improvement, if I may say so? When do we have a lot of sort of good processes of natural selection? And evolution benefits, in Darwin's eyes, from a high degree of variation. So if you have very many different features that you can pick from, it's better than if you have only a few. Competing selection processes. For instance, if you have two breeders who both breed sheep, they will be competing to one another, so they will select interesting variations. They'll come up with innovation. A little path dependency, I'm going into that in a minute. And it helps if there is no isolation and no mere self-fertilization. So if there's cross-fertilization, if we take other influences in, it typically benefits the evolutionary process. And we need a high frequency of reproduction. So if the more we sort of reproduce, the more we try, the better the results. This is Darwin's understanding of how the evolution works. Okay, this was sort of a very quick guide to evolutionary legal theory. Let's now apply this to this case and draw some conclusions from that. This was our starting point, sort of, or we ended here actually with the first set of thoughts. How can we sort of make sense of that? First of all, I think what this case essentially says is, let the parties solve the problem. The court says nothing on friend, it says nothing on patent tickets, it says nothing on exceptional circumstances. So if I evaluate that from an evolutionary perspective, this judgment doesn't bring a lot of innovation, right? Or it doesn't solve these problems at least. And this was sort of a surprise for everyone that was dealing with this matter before, because we expected the court to give us a landmark case here, right? a decision that solves the friend issues, that tells us what is the exceptional circumstances doctrine 2015, what is how do we deal with patent tickets, how can competition law interfere with IP law, and I don't see that in this sort of judgment, or I can see a certain strand there, but rather not so innovative, not so forward-pushing one. And I wondered, why is that so? Can I explain that from an evolutionary perspective? And I guess we can. First of all, we would have to put the Huawei judgment in perspective. You see the line of cases that have been before dealing with this matter, and you also see the time frames that were there. The court is also influenced by the Advocate General and by the European Commission, the Director General for Competition. What is more important even, maybe this strand of thinking, if the court gets a question that is referred to him, there is an enormous influence of the referring court. And the Landgericht Düsseldorf, the Düsseldorf court that brought this case to the court actually, was dealing with an with the German line of thinking on this issue that was basically dealt with in the Orange Book case of the Bundesgerichtshof, the Federal Civil Court in Germany, which had been particularly friendly to proprietors. So they had a similar situation as in the Huawei case in Orange Book, and the Bundesgerichtshof was very friendly to the patent holder and said, yes, basically, or it said the criteria, there's no real danger of having a competition law defense against your claim. The Commission, remember what Munia said, the Commission actually in the Samsung case in 2012 put an opposite stance and was very friendly to the infringer. Yeah? Okay, they took the competition perspective, not so much the IP perspective. And these were the two lines of thinking that the Landgericht Düsseldorf had on its plate and referred to the Huawei to the court. So what they essentially asked the court to do is, please set aside the judgment of our higher authority. This is pretty bold of a German court to say, which is a German lower court, to say the Supreme Court has ruled in a wrong way. Now we don't turn to the Supreme Court again and present our judgment again, but we just turn to the European Court and say, could you please deal with that? And could you please set aside the strict requirements of the German Supreme Court? So this was probably the line of thinking. Just to complete the picture, of course, ever since the court dealt with that case, the situation had to be stabilized, as we would say from an evolutionary perspective, in follow-up cases in Germany. So at present we are discussing in Germany very many cases of what does the court actually mean with this? What is a willingness? What is a sort of a specific offer? What is friend, etc.? So this is the whole picture of that case. And I think we can, from an evolutionary perspective, see a couple of points here. First is we have a very strong path dependence. If we have strong path dependence, we have low innovative evolutionary output. Why do we have strong path dependence? Because the referring court frames it in a way not to solve the patent ticket problem, but to overrule, to set aside the Orange Book judgment by a higher court. The referring court asks very, very detailed questions, and it offers basically two variations on that, namely, either you turn to the Commission approach in Samsung, or you turn to the German approach in Orange Book. And the Advocate General actually doubles this approach and says, yes, I shall confine my observations to exactly this, instead of taking the case and broadening it sort of, or reframing questions, what Advocate Generals once in a while do. I mean, it's usually the court is bound to answer the question that is before him, but the court and the Advocate General have sometimes used these questions to give more guidance than they have in this case. So we have a very strong path that is to be followed here, and path dependence, you may know that from institutional thinking, means once you have sort of a certain path that you follow, once you're on that track, it's very difficult to break free from that and to go into other and to take other options. So we are very strong here in a certain path that is difficult to get away from. Secondly, we have a very low degree of variation. We only have two ideas of what could be done in this case. Either you choose Samsung or you choose Orange Book. That is not a lot, and both solutions are even pretty close. So it's not revolutionary to choose either the one or the other. It would make a difference, of course, but it doesn't make that huge difference. Thirdly, we have no competing selection processes. The Court of Justice is not like a member states court that competes maybe with courts in other member states or with courts on the same level in the member state. It is a sort of unique court that cannot turn to other courts, or that is not under pressure from competing selection processes in a way. And we have a very low level of external influence. This is really striking in this judgment, in my view. We have no analysis of the situation in other member states or the USA. We have very, very limited economic input in this case, so the court does not go into the economics of patent tickets or anything, and it does not go into patent law at all. So this may be normal in some cases, but the Advocate General says, here we have a plethora of actions before the courts of several member states and third countries. And this has given rise to a number of divergent legal approaches. So there is more than just two variations to this. So there could be influences from other fields. So that could enrich the judgment enormously, but the court completely refrains from that, which leads me to the conclusion that this is a reason for why it comes up with such a weak sort of decision in this case, which doesn't bring us a lot forward in the whole debate. And finally, of course, we have a low frequency of reproduction. You may remember that the court rules on such license cases every 7 or 10 years or so. So the court itself does not have a very good yardstick and does not have the possibility of trial and error in a way that, that would foster evolution in this case. I come to the conclusion. What do I make out of this? You may remember that the research question was, how does the Huawei ZTE decision shape the debate of IP and competition law? Firstly, in concrete terms, the case has not yet been decided by the Düsseldorf case, so we don't know exactly what that case the court will do with it. But we have seen other judgment in this matter, and actually the case has triggered a very productive, evolutionary, competitive process in German courts applying the Huawei criteria, which somehow shows that the judgment of the court is just sort of one institution that does not solve a case or that is not the definite word on it, but is again in an evolutionary process, because we have to see what is the timing that we actually have to apply, when do we have to react, etc. So the evolution constantly goes on, and now questions come up that the court never had on its plate because the time was maybe not ripe or so. But this shows to me that we shouldn't overestimate the value of a court judgment, even if it is the Court of Justice of the European Union. This is the very concrete result. Secondly, there are new impulses, and it's one of the advantages of the evolutionary approach. If you really put it into perspective, you see exactly what is new in a certain case. And there are some impulses in this case. They are in small and tiny bits and pieces, but you can sort of identify patterns or paths that the court may take in the next decision. The first is, it acknowledges the messed up situation in standard essential patents. So the court pretty clearly speaks out on the patent law system in these cases as a system that needs reform. Secondly, and maybe most interesting is that it cites the Charter on Fundamental Human Rights, as the starting point for its balancing process. It cites Article 17 and 47, that's access to justice, as the starting points for Huawei, and it balances these rights with Article 102 TFEU. You may know that the treaty and the charter are on the same hierarchical level in European law, which is different at least from German law, where the charter would have would be predominant. This isn't the case here. The Advocate General actually did a pure charter-related weighing process, in that it started with Article 17 in favor of Huawei and Article 16, freedom to conduct a business, in favor of ZTE. So we had a balancing process there. Now we balance actually the intellectual property rights with the TFU. Actually, the court doesn't make much out of this, but it is there, right? So it starts from this point. And finally, which is striking for competition lawyers, I think, is that there are several references to fairness and legitimate expectations that we hadn't seen in competition law before. So I'd never been aware that competition law is about fairness so much, at least antitrust law. I mean, there is other strands of competition law. But in this case, the court often argues with fairness, and some people already, not so much based on this case, but also on other cases, say fairness is a new sort of concept that evolves in competition law, which I find pretty interesting, and this case is certainly interesting in that regard. The key message, though, of the court is that competition law intervenes in IP law only to allow the market players to solve their problems themselves. This is what I take from this negotiating process. Let them do the work themselves. We won't interfere unless this process of negotiating, which essentially is a market process, is hampered by some instance. And if I look at this from this point of view, I think that's even a pretty interesting solution. So the court maybe has some innovative step here in that it says competition law is there to enable market players to solve their problems, so that not one overarching rule like IP stands in between them if they basically start from the same or from a negotiating position. What did this do to competition law? This is the final statement of Margrethe Vestager. You remember, first we step in and enforce, second, we balance the rights. Now, 2017, she says, the best way to solve those issues is sometimes to change the regulations, which means IP regulations, not to apply the competition rules. So if I want to sort of draw a conclusion from the case to the debate between competition law and IP law, I think that after years and years of a hard-fought and raging debate, we are coming to the point that competition law retreats and sees we failed, we will not try again, we leave this mess to the patent people. So I've got a sort of job for you to do and something where we have completely failed. Just sort of as a food of thought in the end, you may of course now, if you think of this, think of the question, is the institutional design of European law and of European judgments, of the Court of Justice, the setup of all that, is that something that is adaptive to change, or should we reform that, or should there be sort of, or how can we ensure that the court comes up with maybe better or more interesting or more innovative rulings than in this case? It has done so before, but sort of the task is to identify what makes the court give an innovative, interesting judgment that adds something to our knowledge rather than sort of retreating to a very, very tiny solution as in this case. Thank you very much.